She needs to be removed from this courtroom. My mother said it clearly, deliberately, the way she said everything, as though the words had been selected in advance and tested for maximum effect. My name is Diana Mercer. I am 54 years old, and the two people sitting across that courtroom from me were the same two people who had taught me to walk, to read, and to never show weakness in front of strangers. They had forgot who taught me the last part. Let me take you back 8 months. Not to the courtroom. Further, to a Sunday afternoon phone call from my brother Kenneth, his voice carrying that particular careful tone people use when they are about to say something they have been rehearsing. "Mom and Dad are filing," he said. "Filing what?" "Competency proceedings. They're claiming you're mentally unfit to manage the estate assets." A pause. "They've already retained counsel." I sat with that for a moment. The estate was my grandmother's, Diana Mercer, who had died 4 months earlier at 91, sharp and deliberate until her final week. She had built the Mercer family's financial holdings across 60 years of careful, patient work. Textile interests, property, a portfolio she had managed personally until she was 87. And she had left controlling authority to me. Not to my father, her son, not to my mother, not to Kenneth. To me. The reasons for that decision were her own. She had shared them with me privately, in her study, 6 months before she died. I had listened and understood and accepted the responsibility with the full weight of what it meant. My parents had not accepted it at all. "When did they file?" I asked. 3 days ago." "And you're telling me now?" Silence on the other end. That silence told me everything about Kenneth's role in what was coming. Not the architect, he didn't have the patience for architecture, but a willing participant, someone who had decided which side of this was more comfortable and had chosen accordingly. "I thought you should know," he said. "Thank you," I said evenly. "I'll take it from here." Here is what my parents believed about me. They believed I was the quiet one, the one who had left the family business at 26 to pursue work they considered eccentric. First a law degree, then 15 years in estate and financial litigation, then a move into something they described to their friends as consulting in the same tone people use for hobbies they don't understand. What I actually did for 15 years before the consulting was litigate estate disputes. Complex ones, multi-generational ones, the kind where old money meets competing claims, meets documents that have been interpreted 6 different ways by 6 different attorneys across 4 decades. I had handled 41 cases. I had lost 3. My grandmother knew this. It was, I believe, a significant part of why she made the decision she made. My parents did not know this, or had chosen not to retain it. In their version of Diana Mercer, I was quiet and competent and slightly disappointing. A daughter who had gone sideways from the family path and done something with it that didn't translate into dinner party conversation. That version of me was about to cause them significant difficulty. The competency filing was thorough. I will give their attorneys credit for that. It was not a frivolous document. It raised genuine legal mechanisms, cited real precedents, and constructed a coherent narrative of a woman making financial decisions with the estate assets that were imprudent, irregular, and potentially damaging to the broader family interests. The financial decisions they cited were real. The characterization of them was entirely false. What they called imprudent restructuring, I had called the unwinding of 3 overlapping liability exposures that my grandmother's estate manager had allowed to accumulate over 7 years. What they called irregular asset movement, I had called the consolidation of 6 poorly performing property holdings into 2 well-positioned ones. What they called potentially damaging, I had called the most straightforward fiduciary cleanup I had encountered in 15 years of practice. But to someone without the technical foundation to evaluate those decisions, to a judge looking at the surface of the documentation without the context beneath it, it could be made to look like something else. That was the strategy. Make it look like something else long enough to get a conservatorship order. Replace me with a court-appointed manager. And restructure the estate distribution in the window before any appeal could be mounted. It was not unsophisticated. It was also not going to work. I retained James Aucheffer, 66 years old, 40 years in estate and probate litigation. The kind of attorney who does not perform for courtrooms, he simply occupies them with a completeness that leaves very little space for anyone else's narrative. He read the competency, filing in one sitting. They've done their homework, he said. Their attorneys have. The financial irregularity argument is the spine of it. If they can get a judge to accept the framing, he paused, it becomes a question of interpretation rather than fact, and interpretation cases are harder. I know, I said. I've litigated 41 of them. He looked at me over the file. Then you know what we need. Context, I said. Every decision documented, sourced, and explained in language that removes the interpretation entirely. Make it fact, not opinion. That's 60 to 90 days of preparation. As I know. And in the meantime, they'll push for an emergency conservatorship, hearing to limit your management authority while the competency case proceeds. I know that too. Diana, he set the file down. Is there anything in the estate decisions that doesn't hold up under full scrutiny? I thought about 41 cases, about the 3 I had lost and what had caused each loss, about the specific decisions I had made with my grandmother's estate in the 4 months since her death. No, I said. You're certain. Every decision has a documented rationale, a comparable precedent, and a measurable outcome already in progress. I met his eyes. They chose the wrong case to bring. He held my gaze for a moment. Then let's make sure the courtroom understands that, he said. The first 60 days were not straightforward. I want to be clear about that, because the version of this story that makes me sound invincible is not the true version. Day 18, I found what I thought was the vulnerability they were going to exploit. A property transaction from month 2 of my management, a sale that, on the surface, had been executed below market assessment. I spent 4 days cert that this was the thread they intended to pull, prepared the defense, built the documentation package. Day 22, I realized I had been wrong. The property transaction was a distraction, something their attorneys had put in the filing knowing I would spend time on it. The real spine of their argument was the liability unwinding. Specifically, one aspect of it that intersected with a decision my grandmother's estate manager had made 3 years before her death. A decision that created an ambiguity in the ownership structure of the largest property holding. An ambiguity I had documented and addressed, but not in a way that was immediately legible to someone outside the field. I sat in my office at midnight on day 22, looking at what I had missed and feeling the specific cold clarity of understanding that the case I had been preparing was not quite the case I needed to prepare. I spent 3 days rebuilding. On day 25, I found the documentation my grandmother had signed in the final year of her life, a formal clarification of the ownership structure, witnessed, notarized, and filed in a county records office 3 states away from where the estate was being administered. Filed deliberately by my grandmother, who had understood, I believe, that her son would challenge her decision and had taken the precaution of establishing the clearest possible paper trail for the person she had chosen to protect it. She had been sharp until her final week. She had also, it turned out, been several moves ahead. The ownership clarification changed everything. Not because it was a dramatic revelation. It wasn't. It was a quiet document, formally worded, entirely unambiguous. But it removed the central ambiguity that my parents' case depended on. Without that ambiguity, the liability unwinding wasn't an irregular decision made by a potentially incompetent manager. It was the correct and necessary action of a fully authorized administrator, following a clearly documented ownership structure. I gave James the complete package on day 63. He read it without speaking. Then he set it down and said, "Where did you find the county filing?" "I looked for it," I said, once I understood what they were actually arguing. "Your grandmother filed this 3 years ago." "Yes." Before she showed any significant decline. "Yes." So she anticipated this challenge. She anticipated her son, I said. She knew him for 70 years. She prepared accordingly. James was quiet for a moment. Then, "Diana, this doesn't just answer their case. It demonstrates that the estate decision-making has been sound, documented, and consistent with the grantor's clearly expressed intentions from a period of unquestionable mental clarity." "Yes." Their competency argument doesn't weaken. It inverts. They've brought a case that, with this documentation, actually demonstrates the opposite of what they intended. "Yes," I said, "I know." He looked at me across the desk. "Your grandmother was a formidable woman," he said. "She was," I said. "I learned from her." There was one more thing. Something I had found on day 51 and spent 2 weeks verifying before I told James. The competency filing had been submitted by my parents' attorneys, but the financial analysis embedded in it, the specific characterization of my estate decisions as irregular and potentially damaging, had been prepared by an outside consultant, a financial analyst whose firm had been retained specifically for this proceeding. That analyst's firm had a relationship with a property development group. That property development group had made 2 approaches to the Mercer estate in the previous 18 months, approaches I had declined, seeking to acquire the largest property holding at below-market terms. The same property holding whose ownership structure my parents' case depended on destabilizing. The competency filing was not simply a family dispute about estate management. It was, at least in part, a mechanism to create the conditions under which a specific property acquisition could be forced through. My parents may or may not have understood that fully. I genuinely do not know. What I know is that they had been given a financial analysis by people with a direct interest in the outcome, and had used it as the foundation of a legal case against their own daughter. I gave James this on day 65. He read it slowly, set it down. "Your parents may have been used," he said carefully. "Yes." "That doesn't excuse the filing." "No, it doesn't. But it changes the moral shape of it somewhat." I thought about my mother's voice on the phone when Kenneth had finally told me, not the words, the tone. The particular tone of someone who has been told a story so completely that they have forgotten it was told to them. It changes it somewhat, I agreed. The courtroom was full on the day of the hearing. Family members I hadn't seen in years. My parents' attorneys, 4 of them, which told me something about their confidence level. Kenneth, sitting 3 rows behind my parents, not meeting my eyes. My parents sat at the petitioner's table. My mother looked determined, prepared, the way she always looked when she had decided something was right. My father looked older than I remembered. And I noticed this only because I had spent 15 years reading courtrooms, slightly uncertain. The particular quality of a man who has committed to a position and is only now beginning to question the foundation beneath it. I sat at the respondent's table with James and 2 associates and 4 bankers' boxes of documentation and my grandmother's county filing on top where I could see it. The judge was Honorable Patricia Shen, 58 years old, 15 years on the probate bench. The kind of judicial stillness that comes from having seen every version of family conflict that money and grief can produce. She entered, we rose, she sat, we sat. She opened the file. The petitioner's attorney, senior partner, practiced, the voice of a man accustomed to controlling courtroom temperature, began his opening with confidence. The financial irregularities, the pattern of decisions, the family's concern, the need for court oversight. He spoke for 14 minutes. He was good. He had also, I noted, not yet seen the county filing. James rose for the respondent. He spoke for 6 minutes. He introduced the ownership clarification document, the notarized filing, the date, the witnesses, my grandmother's signature and the certification of her mental capacity at the time of signing. Standard language in such documents, meaningless in most cases, decisive in this one. He placed the property development group's relationship with the financial analyst in the record. He noted the 2 declined acquisition approaches. He did not editorialize. He did not perform. He simply placed each fact in front of the court with the quiet precision of someone building something that doesn't require decoration to stand. When he sat down, the courtroom was very quiet. The petitioner's lead attorney was on his feet immediately. "Your Honor, we'd request time to review." Judge Shen held up one hand. She was reading. The courtroom waited. I watched my father's face, watched the uncertainty I had noticed earlier become something more definite, watched him lean toward my mother and say something I couldn't hear, watched my mother's prepared expression hold for a moment, then fracture, just slightly, at the edges. The judge read for 4 minutes. Then she looked up. Not at the attorneys, not at my parents. At me. For exactly 3 seconds. Then she looked back at the file. "The petition for competency review is denied," she said. "The documentation before this court demonstrates consistent, well-reasoned, and properly authorized estate management fully aligned with the grantor's clearly expressed intentions." She closed the file. The petitioner's financial analysis is hereby noted as having been prepared by a party with a disclosed material interest in the outcome. The court will be referring this matter for a separate review. As she stood, we rose. As she left, the courtroom froze. Not metaphorically, literally. For approximately 4 seconds, nobody moved, nobody spoke. The petitioner's attorneys stood in place. Kenneth sat very still in the third row. My mother turned and looked at me across the room. I looked back. I did not smile. I did not perform anything. I simply looked at her the way I had been looking at courtrooms for 15 years, directly, clearly, without the need for the moment to be anything other than what it was. My father had his head down. I gathered my papers, stood, nodded to James. Walked out. In the corridor outside, James fell into step beside me. The referral for separate review, he said. That's going to be uncomfortable for their financial analyst. Yes, I said. Potentially for the property development group as well. Yes. He was quiet for a moment. Your parents may face exposure depending on what the review finds. As I know. How do you feel about that? I thought about it honestly. I feel that my grandmother spent 60 years building something carefully, I said, and I feel that I was asked to protect it, and I feel that I did. He nodded. We walked to the elevator. 3 weeks later, my father called. Not my mother, my father's. He spoke for a long time, carefully, haltingly, the way people speak when they are constructing an honest sentence for the first time in a long while. He said he hadn't understood the full picture of what the financial analysts had presented, that he had been told a version of my estate decisions that he now understood had been shaped by people with reasons of their own. He said that was not an excuse. He said he had been wrong to sign the filing without speaking to me first. He said he was sorry. I listened to the whole thing without interrupting. Then I said, I know you believed it. That doesn't make it right. No, it doesn't. A long silence. Your grandmother, he said, she knew you'd handle it. Yes, I said, she did. She always understood you better than I did. I looked out the window of my office at the city in the early evening light. She had 60 years of practice, I said. You still have time. He was quiet for a moment. Do I? He asked. Call me again, I said. Not about the estate, just call. I heard him exhale. I will, he said. I will.